Welcome to the European Law Unbound podcast series. I'm Maria Bartel, Professor of Transnational Private Law at the University of Amsterdam and the co-president pro tempore of the European Law Unbound Society. This podcast series was recorded in Prague during our inaugural conference in September 25, and we are thrilled to share it with you. In these episodes, you will discover fascinating law in Europe research from our many participants brought to life with their fresh impressions and insights from the conference itself. We hope you will enjoy these conversations as we look ahead to our second annual conference coming to Lisbon in September 26. Stay connected with us on LinkedIn to keep up with the latest news, updates and developments from the European Law Unbound Society. We are just getting started and we'd love to have you along for the journey.
Welcome everybody to our podcast. I'm your host, Jaroslav Denemark from the Department of European Studies here at Charles University. We have another special episode of our podcast that is focused on the conference EU Law Unbound. And I have here with me another special guest, and it is Maria Magierska. Who is currently senior lecturer at Maastricht University. Thank you for being here and accepting our invitation.
Yeah, thanks for having me.
We should be talking a bit about your research and what you have presented here today. So could you introduce us something about your topic?
Yeah, thanks so much. I'm very happy to be here, as I said, because Charles University was where I did my Erasmus, so it's nice to be back. And, I brought here to a topic which is not necessarily strictly linked to what I'm doing.
Mm-hmm.
I'm a data protection lawyer, and I'm researching mostly enforcement of GDPR, enforcement of digital rights. And how I ended up talking about GDPR and journalists, which was what I was talking about now at the panel, was because during the discussion I had with my friends and during my research on enforcement, I realized how deeply the data protection under enforcement problem is connected to actually the pillars of democracy that we have. It's really embedded in it. And this is, how we came up with this panel where I had other guests, Paulina Milewska, Zuzanna Nowicka, that were talking. Also, they are media journalists. They're media law journalists.
Mm-hmm.
And we were discussing different angles of how it is what does it mean to even be a journalist now during this digital age. And my specific angle was the relevance of data protection to media today. And I think there are three angles that you can approach this topic. So first is this question of the systemic relevance, which we have. Of course, there's journalistic exemptions in the GDPR, and there are many problems with that. We have the right to be forgotten, and I heard that you know very well that there are some troubles on how to understand it. And then we have the second angle that really interests me as well. It's the weaponization of GDPR.
Mm-hmm.
So we've noticed that GDPR is used as a basis for so-called strategic litigation against public participation.
Mm-hmm.
So journalists are attacked with GDPR provisions to hamper the publications. And finally, that was the third angle, but really important as well, was the economic relevance. So GDPR is really a general law, as you know.
Mm-hmm.
So it applies to controllers universally. There is no thresholds like under the AI Act, apart from certain provisions.
Yes.
This means that when advertisements or revenues are source of the revenues for the publishers, for the big tech companies, they are applicable to the same rules. And so we have the problem, we had this discussion now with pay or consent that brings different answers depending on whether you are a big tech company or whether you are a media provider, which not necessarily reflects the actual powers of these actors. So these were just three cores of what I was discussing today with my panelists, and I've really learned a lot as well from this media law perspective. But in principle, that was my focus.
And if we briefly talk about the fundamentals of your topics, when we talk about the right for privacy or data protection, another fundamental right that it's usually in a fight, it's the freedom of speech, right? And that's what connects it to the journalism.
Yes, exactly. And because even if we think of it, the very basis of the right to privacy, they were built from this conflict. The very first article of right to privacy, the Warren and Brydon's piece from 1888, was actually written in response to the frustration that Warren and writers were suffering because they were members of the New York Society. And it was around that time that the Kodak camera has been invented. And so they were frustrated that suddenly the press is infiltrating. There was some wedding that it was infiltrated. It was also the general gossip. And so they wrote famously, "We have the right to be alone," from the side of government, but also from the press. And they also introduced in this article, so it's really like hundreds of years ago, that there is this public or general interests should not overweight the right to privacy.
Yes.
And it's always the question of, unless someone is, it is connected to the public office that is held by someone, we, as no matter what we are doing in our life, we should have the right to privacy. And this principle, as much as old it is and it's coming from the US, it still stands there in European courts.
But does it? Because we had many cases before the ECG that were directly connected to the the balance between the right to privacy and the freedom of speech, and we cannot tell, or you may correct me, that one of the rights is above one another.
No, absolutely not. There is always balancing that needs to be there. And what I've noticed is also that the courts tend to replicate this thinking of data protection, data privacy, of the right to control your information, which is also quite limited thinking if you consider data protection, at least. It has also this collective aspect that's kind of ignored here. But in general, yes, the balancing is very crucial here. So we have, the very famous Exata Media cases, both from ECHR and from ECJ. And I always like to give this example of von Hanover, so two cases of Monaco princess. First one where it was just she was just the pictures were taken of her when she was doing shopping, I think, or she was on holiday, right? And the court ruled, it was ECHR, not the Court of Justice yet, that it's she has rights to her privacy. And then, of course, there was another case a couple of years later of her father's, and it was a different case this time because, of course, the court ruled here that since it's related to this, the health of the ruler of Monaco, it is matter of public interest.
Yes.
So here, I like this comparison of the two cases because it shows kind of the tension that it's really what can fall within the public interest, what can fall beyond. Though in practice, of course, it got much trickier now under the. We are going to talk about the right to be forgotten, I imagine, and that's something that maybe used to be more straightforward, never was, but at least analog became much more tricky under the current reality.
So is the public interest what is important when we are balancing those two rights? It's the most important thing, right? Public interest.
Public interest, yes.
But it also applies to right to be forgotten.
Yes.
Do I have the right to be forgotten, or is there a public interest not to be forgotten?
As you know, as any lawyer would tell you, it depends.
Yes.
And
case by case.
It depends on the case by case basis, and we have it. Of course, we started with Google Spain, where there was this balancing of the public interest, access to information versus the nature, the sensitivity of data protection, the interest of public, that was crucial, but also the duration of this. So here was the question of really outdated conviction of one person, and actually it's obviously a paradox because Mr. Gonzalez, this is how he made it. No one will.
Barbara Streisand effect.
Absolutely. So now no one will forget that he had outdated.
Mr. Costeja Gonzalez, yes.
Yeah, like no one will forget that he had outdated financial liabilities.
Yes.
But that was the basis for this case. And
but it was before GDPR.
It was before the GDPR, and this was also an attempt for the court to kind of write it into. So that's how it stayed into. It was later implemented into the GDPR. And later also clarified with the two cases with Google as the participant and JC. So in the first case, there was the territorial scope assessed, which is very fascinating. Like it's also there in the data protection field from the beginning. What is the scope of data protection in the internet where you can actually access the website from any country in the world? So if you remember, there was the Linkfist case, the famous case of the parish lady that published information about her parishioner breaking a leg. and it was deemed by the court illegal because it was processing sensitive information.
Yeah.
And so Google versus CNIL was kind of also addressing this problem, saying that, well, of course, we can't have the global outreach of data protection. It has to be, there's no global dereferencing obligation. The listing is only within the EU. Now, to what extent is working in practice? How it's technically possible?
That was my question. Is there actually extraterritoriality of GDPR?
That's a very good question. Because
I think there is.
So there is. Like if you look on Article 3, of course, of GDPR, yes, there is certainly. However, if you look on the reality of enforcement of Article 3, it is the legal loophole. So we had it, like maybe stepping aside from right to be forgotten cases and practicalities of it. We had recently a very big scandal, even I would say, with Clearview AI. So Clearview is this facial recognition startup that they are. They are taking your, they are searching your photos in the internet and they are providing information to whoever asks, but it's quite expensive, who you are indeed. So it's very wide scope of data processing that's taking place. And of course, there were actions. There were actions in couple of member states because Clearview AI is not. They don't have the main establishment in Europe. They are still functioning. I think they are registered in Israel and in the United States, if I am not wrong here. So basically what they said, they got these fines from, I think it was the Italian, the Belgium, I don't want to say it wrongly, but basically they dismissed these cases, the fines. They said, we are not based in Europe. We are not respecting you at all. And they did respect, though, the UK fine, I think, if I remember. But that's the big problem with that, because we have the Chapter 5, we have the transfers. But here what's happening when you are just using the services of the other provider, this is against the linguist case, it's not a data transfer. So all these rules that we have, the adequacy decisions, like the SECs and so on, they are not applicable here. It's just the question of the scope.
Okay.
But in reality, how to enforce it, it's a problem because that's like the basic rules of the international law that you can't exert your jurisdiction over different member states, the different states outside of.
So can you ban the services in the EU?
That's, again, another big topic that we have here. This is what many of them did. So after the Schrems cases, when the data transfers were deemed illegal to the US, this is at least some of them tried to locate the data in Europe. But then you have the question of like, who will store this data? You have Ireland that is really overwhelmed energetically. Like this is an environmental question that is going here into practice. Well, that's a big discussion that there is now. And with the Clearview cases, there's also DeepSeek case, and that's quite similar. Like the courts are, the DPAs, there was very interesting case now in Germany where the DPA tried to use the DSA to try to walk through this problem of extraterritoriality. But in the end, it goes down to the principles of international law. So yes. And actually the GDPR is not the only global law that has this provision. Like I know there are, for example, definitely African countries, Nigeria and Kenya, I think they have even written it into their data protection laws as well, even in stronger words than GDPR. But still, since they are not that competitive economies, I think it's really treated as a blanket provision. Like it's not really understood well. And so with the GDPR, at least there's some like recognition of this principle. But in the end, the problem is very there's really a dilemma on how to tackle this. And, I think the only solution that we have, but it's also quite problematic, would be the international treaty for data processing or some way around it, plus the ad hoc cooperation with data protection authorities that they just write, they do memoranda of understanding, and say you have the Polish DPA working with, I don't know, Israeli DPA, like some so reality.
You mean that we should have a treaty for data protection like on the UN level? Well,
so that's one of the solutions that was proposed. Definitely Japan was very much in favor of that a couple of years ago. And there are people who are really in favor of it. Now the question is, of course, like, what should be in such a treaty? especially given that not actually Europe is unique in the approach to data protection still, on this fundamental rights-based approach.
Yes.
The other countries are still seeing it more as an economic right.
Yes.
So we say Brussels effect, and I think we will have even Anu Bradford here on this conference speaking, but that other countries indeed replicated GDPR, but mostly focusing on this economic-based
It's right.
element.
In USA, they don't even know if it's a human right, right?
Exactly, it's not even
Freedom of
recognized
speech,
as.
right? It's human right. It's our constitution, but right to privacy, no.
No, it's not recognized in the US, and also in the other countries. Even if it is, I think when it comes to data protection rules, they tend to more take this accountability element,
Yes.
the freedom to flow, freedom to data flows rather than the protection of the fundamental rights.
Yes. Yes.
So it's then it's also it's this question, like, if we allow, like, not now, I think it's not possible, but a couple of years ago Japan was really lobbying to have this free data flows treaty kind of, but there was the question, of course, what does it mean for us? What does it mean for the global south if we are just in Europe and global south in general just the consumers of the services? And if you have the free data treaty, kind of like as they wanted, like they wanted really to have it more deregulatory and self-regulation element rather than outright regulation, then it means, what does it mean for us if we just continue to be more consumers because we don't have enough protections?
Yes.
And so we will obviously see how it proceeds. Now I think at this environment we are far from having this treaty anyway, but these discussions keep coming back, and it's fascinating to follow them and have to also like acknowledge different perspectives that we have from them.
But if we get back to journalism, the topic.
Yeah.
I know that we could talk about this topic hours and hours and hours. It's endless. But what was interesting, and you said it at the beginning, how can be GDPR used to actually how can it be used as a weapon against freedom of journalism?
So this is the question in general that journalists at their work, especially in countries that are a bit suffering the rule of law crisis in Europe.
Maybe why we have the directive, the strategic lawsuit against public participation.
Exactly. It is on the table. It has been, I think, just introduced.
Yes.
However, with the GDPR specifically, there's always a question of how to define what strategic litigation against public participation, what falls into that. And I still don't think this directive has handled it explicitly. I think this is still quite blurry, especially when it comes to GDPR. So we've seen it particularly in Romania and Hungary. But there are all these little cases when just the journalists are chased for publishing some data, essentially for this. So again, like, right to be forgotten plays a huge part of it. Mm-hmm. So they basically, the public officials, they are stating, oh, this is not public interest, this is my private life, and they are claiming, they are chasing journalists for like taking down what they wrote. That's general principle of what's happening. And there's also a question of the journalistic exemption that I maybe want to address here. So under the GDPR, it's really one of those elements that's really fragmented because each member state applies different rules. There is no regular idea on how these do. So they are really applying, some of them restricting whole chapters, others just elements of these chapters. It's really not coordinated, but that was kind of the idea. But what's really specific, what really controversial is the way Romania implemented this provision, because they, instead of having it in like their media law, like very specific articles, they did very broad provision that entire chapters of GDPR can be exempted only in this where personal data were manifestly made public, where they are closely related to data subject position as a public person, closely or public nature of the infringement. But many people were said this is too narrow, and indeed this is what happened in Romania. That
what is closely related?
That even legitimate journalists, because there's usually this, like if you are a professional journalist, let's say, you can even automatically be considered as like falling into this exemption when you process data. Here is even this legitimate journalistic processing might fall outside of this process. So it's really against even the the General Court of Justice understanding of it, which
Yes.
it says explicitly this should be brought. So Romania is very narrow here. And indeed, we saw the Romanian Data Protection Authority. There was this case from RISE project in 2019, so even quite early during the GDPR, where RISE project was publishing information about the corruption scandal involving a politician, and it was investigating for the fraud. And of course, the DPA. So the DPA, what they claimed, there was their own volition action. Although it was later revealed there was also a complaint from this politician made a day before. They they sent series of questions to the journalist who authored the article, asked to remove the information, asked to reveal the sources as well. And they threatened to issue a penalty up to this 20 million euros, which is like very rarely it happens. But it indeed happened, and it's a lot of burden on the.
It was argued that the GDPR was breached.
Yes, for for this balance question that it was not public interest here, so it's not falling into this journalistic exemption, and so they can fine the journalist, the journal, and it's really problematic if you also think it's little investigative journals. They don't have, they are not the size of big tech companies, and they can't handle the fines. It's actually a big blow on their functioning, right?
But it's clear that in the countries like Romania, especially, it's aimed at this investigative journalist.
Yes, and unfortunately it happens a lot. So another case was maybe even more obvious, was in Hungary. So that was the Forbes Hungary. They published their list of the 50 richest Hungarians, including the owners of the Hell Energy, which is a Hungarian energy drink company. So they objected for the processing, and they said this is GDPR, and they in general issued even the preliminary injunction to stop distribution of the Forbes article about them. And so they don't even challenge the truth of it.
Yes.
They claimed, yes, we are kind of the richest people in Hungary.
But you're not allowed to
But they say it was like, there's no legal basis for data processing. And because it's Hungary and the data protection authorities fined Forbes for this. And they said it's not falling into the journalistic exemption. And it claimed that indeed it's not the legitimate interest for Forbes to process this data. The case ended up in the courts, and I think that it was also there was a separate challenge brought by Forbes to the constitutional appeal, and some measure remains in effect. But the litigation also extended over years, and for the journalists, a lot of pressure that they put here. And this is only element. GDPR is only part of the puzzle. They are using all the other laws as well. We also saw it in Poland that not against journalists but against NGOs. I saw so NGOs kind of competing between each other, with the fundamentalist Catholic organization suing or filing complaints to the DPA against the pro-abortion organization, and with valid grounds of that sense, protection of sensitive data, because they are just had information that the organization may not process data accordingly, because there's this grassroots organization, they had to have let's say Excel sheet with the information of a woman who wanted to reach out for help to get an abortion, which is in Poland it's illegal. So that was the basis for it, and kind of the example of how it can be used in this internal battles between different perspectives on certain topics, which is not necessarily
different ideologies.
Yeah.
But can somehow Media Freedom Act help?
We'll see.
Because this clearly is directly the state is trying to prevent to publish information about their politicians and other public personnel that is in public interest.
Yes, absolutely, and I hope that the Media Act will change it. Like here, this situation where I think a bit unprecedented, what happened in Romania and Hungary, this was also the cases I think in Lithuania, but even in France, we these cases with right to be forgotten claims kind of usually under the GDPR. I think it was kind of unexpected outcome side of the GDPR functioning, which like particularly when it comes to this question of Romania, I think the way they implemented it, it's here also perhaps the role for the Commission even to investigate whether it's the EU law being implemented like with the respect of like the principle of equivalence, effectiveness, and so on, right? Because it's very controversial here.
Yes.
And we had it like there were also constitutional judgments in Austria and in Bulgaria that take down the way they implemented the journalistic exemptions by their own constitutional courts, saying that it was just too broad or too vague. And it should be more specific. So there is practice that shows that indeed it's not just a blanket provision to do anything to just shut down the GDPR completely. It has to be very. It has to allow for this balancing.
But the position of ECJ is clear in this matter, right?
I mean, to a certain extent, because there wasn't, like this is what we can read, infer from this previous judgments. There is no pending case. And let me just give you the specific. It's like Legal News Desk Sweden. So 2 weeks ago, there was the AG opinion. And the case is concerning the legal database. The one that publishes criminal proceedings. So it's not. So there is a discussion whether this legal database, whether if they are just scraping information, do they mean they are this is journalistic exemption? And the case ended up in the court. And recently there was the AG opinion of Advocate Spunner, who is also here at this conference, and he actually even add up to this question of Article 85. To maybe finally define what is the journalistic exemption, what is the scope. And he here, even though court used to avoid maybe determining per se what can be journalism or not, and applying this broad understanding, he says this, that to his opinion, activity which consists of just making available to the public this criminal records in return for payment, but without any processing, editing, like doing the journalistic work, it should not fall into this journalistic purposes exemption.
Okay.
Like this is what he wrote. He also claimed that this principle of Article 85, this exemption, should not be absolute. And because there is actually with Article 85, which is the way it's formulated, you can exempt GDPR for journalistic purposes from Chapter 2, 3, 4, 5, 6, 8. 7, but not 8, which means that you can exempt the supervision of the DPAs, but then the remedies are still there.
Yes.
So it really creates a bit of the problem in these countries that were indeed that use this exemption on to what extent actually can you exempt from the supervision of the DPA if you have Article 8 then like the right to file the complaint and with the DPA and so on. So this is also on the table in this case. So I'm very looking forward to see what the court is saying.
The thing that the general advocate have written about the journalism and what is journalism, what isn't the journalism, it's similar to the case. It was in Finland where they published the financial statements.
Yeah, the Sata Media case.
Yeah, Sata Media case. Yeah. And they said something similar, right? They said, if you only make it publicly available without any further processing, then it's not a journalism.
Exactly.
Right?
Yes.
But then what journalism is, if you make a video in a police station and then you make it public in the public internet.
That was another case, the Budvis case, where, again, like if you are a YouTuber, but if this person wasn't even, I'm not sure if he was a YouTuber, if he was just...
I don't think he was.
He was just publishing it, like just uploaded it on YouTube.
Abuse.
And here, again, it was this broad understanding that it was the feeding the public debate, if I remember, or relevance to the public debate. So here it falls within the journalistic purposes. No?
Yes. So you think that we will have a clear definition?
I hope so. I hope so. We should absolutely, because here is the question of these databases that are scrapping information. So similar to Sata Media, indeed, and they are really everywhere. There are different forms of these databases, and that are just there, like for the making profit of like publishing information, right? Like another thing I'm just now thinking of, like what with the news generators websites that are just, I don't know, like doing AI generated information.
Is it journalism?
Is it journalism or not, right? And so I think we will see much more discussions on that in the future.
Well, it's also affecting the Russian troll farms.
Oh
right?
yeah, absolutely, right? Because like
And those
technically,
disinformation media.
yes, like
Yeah.
like should disinformation be treated as journalism if you like, yeah,
Do they have exemption from right to be forgotten if it's disinformation?
I
I think that they have not. They don't have
not
the
explicitly,
exemption.
yes,
Yeah,
but well, if we carry
because
on,
the information should be truthful. Right?
yes, exactly.
To
So
have the
that's
exception.
so I think you can argue, yes, that, yeah, and it's always this question of balancing.
Yes.
So,
There's always a question of
yeah.
that.
And everything depends. You know,
Yeah.
so
So thank you very much.
thank you so much. It was really
It
a
was
pleasure.
from GDPR to freedom of
Yeah.
speech to right to be forgotten to
That's
to
what I
media,
like.
But yeah.
That's what I like about GDPR because you end up talking about everything.
But yeah. Because
It's-
GDPR is about everything. That's
Yeah.
right. Thank you very much,
Thank you so
and
much.
thank you that you have accepted our invitation.
Thank you. It was really a pleasure.